The third hearing on legalizing same-sex marriage concluded yesterday in the Supreme Court. Earlier on Wednesday, contradicting Centre's argument, Chief Justice of India D.Y. Chandrachud had observed that there is no data from the government that states same-sex marriage is urban or elite. So let's see what all was argued in the court yesterday. Senior Advocate Singhvi and CJI commented on the interpretation of the Special Marriage Act. Reading an article on Parliament-made laws' interpretation, which Singhvi says is the heart of this case, he points to three tests to be carried out: general thrust of the legislation, court's institutional capacity, the fundamental rights involved. The CJI, then speaking of the Special Marriage Act, said, and I quote, "By decriminalizing homosexuality have not just recognized relationships between the same gender, but have also recognized implicitly the fact that people of the same sex would be in stable relationships." Singhvi argued that in same-sex marriages, the minimum age of the marriage, as exists for homosexual people at the moment, will also apply: 18 for women and 21 for men. The age will apply according to the gender the person identifies with. Singhvi added that the focus is on the discriminatory parts of the provisions of law. When Singhvi said that the provisions like rape won't apply to those in such relationships, the court asked him why not. Singhvi then went on to state rape was a criminal offence and defined it as, and I quote, non-consensual penile vaginal penetration, and so it would not apply on same-sex relationships. Singhvi argued that issues such as marital rape in same-sex marriages, and I quote, can be ironed out later. He said that marital rape is not recognized in this country, it's still pending, and that today rape is not a recognized crime in marriage. Singhvi made a point that Special Marriage Act's 30-day notice period is, and I quote, invasive of privacy of those intending to marry. Advocate Ramachandran took over and started his argument by describing his petitioners, making a point that they are not elite as the centre had argued. Adding that the reason for stating the background of these petitioners and others like them was that the institution of marriage is not just a gateway to various socio-economic rights, but it is also a societal protection from their natal families. He added that marriage is also a societal recognition which protects from society and from own parental ties in given cases. In agreement with the CJI, Ramachandran added that his right to health should include the right to have appropriate medical decisions taken for him by the person he loves. Ramachandran argued that the fundamental right to marry is read into Article 21 and he can't be asked to give notice of an exercise of his fundamental rights. Senior Advocate Ramachandran then traced the history of Special Marriage Act.